Hi everyone, welcome back to my YouTube channel. In today's video, I will be talking about some of the frequently asked questions that are related to HIPAA, privacy rules, minimum necessary restrictions. Let's dive right in. How are covered entities expected to determine what is the minimum necessary information that can be used, disclosed, or requested for a particular purpose? The HIPAA privacy rule requires a covered entity to make reasonable efforts to limit use, disclosure of, and request for protected health information to the minimum necessary to accomplish the intended purpose. To allow covered entities the flexibility to address their unique circumstances, the rule requires covered entities to make their own assessment of what protected health information is reasonably necessary for a particular purpose, given the characteristics of their business and workforce, and to implement policies and procedures accordingly. This is not an absolute standard that covered entities need not limit information uses or disclosures to those that are absolutely needed to serve the purpose. Rather, this is a reasonableness standard that calls for an approach consistent with the best practices and guidelines already used by many providers and plans today to limit the unnecessary sharing of medical information. The minimum necessary standard requires covered entities to evaluate their practices and enhance protections as needed to limit unnecessary or inappropriate access to protected health information. It is intended to reflect and be consistent with, not override, professional judgment and standards. Therefore, it is expected that covered entities will utilize the input of prudent professionals involved in healthcare activities when developing policies and procedures that appropriately limit access to personal health information without sacrificing the quality of health care. Must the HIPAA privacy rules minimum necessary standard to be applied to uses or disclosures that are authorized by an individual? No. Uses and disclosures that are authorized by the individual are exempt from the minimum necessary requirements. For example, if a covered healthcare provider receives an individual's authorization to disclose medical information to a life insurer for underwriting purposes, the provider is permitted to disclose the information requested on the authorization without making any minimum necessary determination. The authorization must meet the requirements of Title 45 Code of Federal Regulation 164.508. Are providers required to make a minimum necessary determination to disclose to federal or state agencies such as the Social Security Administration or its affiliated agencies for individuals' applications for federal or state benefits? The answer is no. These disclosures must be authorized by an individual and therefore are exempt from the HIPAA privacy rules minimum necessary requirements. Furthermore, use of the provider's own authorization form is not required. Providers can accept an agency's authorization form as long as it meets the requirements of Title 45 Code of Federal Regulation 164.508 of the Privacy Rule. Is a covered entity required to apply the HIPAA privacy rules minimum necessary standard to a disclosure of protected health information it makes to another covered entity? Covered entities are required to apply the minimum necessary standard to their own request for protected health information. One covered entity may reasonably rely on another covered entity's request as the minimum necessary and then does not need to engage in a separate minimum necessary determination. However, if a covered entity does not agree that the amount of information requested by another covered entity is reasonably necessary for the purpose, it is up to both covered entities to negotiate a resolution of the dispute as to the amount of information needed. Nothing in the privacy rule prevents a covered entity from discussing its concerns with another covered entity, making a request, and negotiating an information exchange that meets the needs of both parties. Are business associates required to restrict their uses and disclosures to the minimum necessary? May a covered entity reasonably rely on a request from a covered entity's business associate as the minimum necessary? A covered entity's contract with a business associate may not authorize the business associate to use or further disclose the information in a manner that would violate the HIPAA privacy rule if done by the covered entity. Thus, a business associate contract must limit the business associate's uses and disclosures of, as well as requests for, protected health information to be consistent with the covered entity's minimum necessary policies and procedures. Given that a business associate contract must limit a business associate's request for protected health information on behalf of a covered entity to that which is reasonably necessary to accomplish the intended purpose, a covered entity is permitted to reasonably rely on such request from a business associate of another covered entity as the minimum necessary. With the reference slide, I conclude my presentation here. Hope you found this information useful. If you enjoyed this video, please consider subscribing to my channel. Thank you for watching. Bye now.